In order to simulate your most exquisite fine dining experience, we're going to have a second seating. Melinda Hensel, Maury Baskin will be back. Robert Godzinez, Ronald Holland. You may proceed.
Thank you. My name is Melinda Hensel. I'm an in-house counsel with the International Union of Operating Engineers, Local 150. Held that position for about 12 years, and prior to that, I worked for a private firm on the union side. I'd like to thank the board very much for having me here today and giving me an opportunity to present my views on what I think are some very, very important changes that the board is considering making.
Ms. Hensel, can you bring your mic a little closer to you?
I'm sorry, that's a problem I routinely have. I'm very soft-spoken.
Aren't we all?
Well, some of us. This proposed rule that a respondent party to a petition provide a position statement on a pre-election issue is hardly some radical policy shift, but it is a common sense approach to streamline and increase the efficiency in the board procedures. A requirement that a party state a specific position is in line with the obligations that are imposed under the Federal Rules of Civil Procedure. In 26A, when you start a piece of litigation, you're required to identify your witnesses and what they have knowledge of. That gives the opposing party the opportunity to investigate the claims made by the opponent. We make position statements before various other administrative agencies. We take positions in arbitration. Taking a position is not an imposition. In addition, in litigation, we also file pretrial orders before we head to trial because the judge wants to narrow the issues. The judge wants to expedite the case. There is no reason to spend 12 days litigating irrelevant, ridiculous notions when a simple statement of what each side intended to present would narrow and have it finished in 2 days. I would say that due process is the cornerstone of every legal proceeding in the United States, or at least it should be. I feel that in this context, the employer not having to take a position is one of the ways in which due process is not served. You've heard some of my colleagues say it's incredibly difficult to prepare for a hearing when you don't know what they're going to be proposing. I think from all perspectives, it does seem universally agreed that this act is about protecting employee rights. It's not necessarily about me, and it's not necessarily about Mr. Employer. It's about a group of employees who want to have a vote. They've expressed their intent to do so by signing the authorization cards, and at that point it becomes the board's job to get that petition to a vote. The dissent to the rules specifically did point out that having a question concerning representation is very disruptive to the workforce. Indeed it is. I've worked with these people. I have experienced the disruption myself as part of an organizing campaign. It is incredibly disruptive, and therefore the board is not serving the employees that the act is meant to serve when it allows an employer to play games. Inclusion of the rule requiring the position statement will allow the parties to determine ahead of time if there is some genuine issue that is in dispute. It's going to require a party to give some serious thought before they get to hearing of what it is that they're going to be presenting, as opposed to, well, I'll just get there and I'll make it up as I go, because I literally have seen that situation. Another way requiring the written position statement can reduce delay. I had a case a few years back in which the employer didn't refuse to state its positions, but it vaguely said, well, we have various reasons why that the petition should be dismissed. It was all based on paper. I sent a letter to the board agent as well as the employer asking for a conference ahead of time, saying, can't we reduce the scope and length of the hearing if we can't just get together on, I understand what your positions are, but present the paper, and maybe we can stipulate, and then we don't have to put on a witness to say, yes, indeed, the settlement agreement was signed. We did that, and guess what? I think we cut at least a day off of that hearing. It didn't stop the employer from showing up the day of hearing and announcing that the day prior it had recognized another union. So, you know, requiring the written position statements the day of hearing doesn't take away the element of surprise. Of course, that is still there. Requiring the written statement will also go a long way towards making it easier to deal with the case handling manual prohibition against harassment. When you don't know, I'm sorry, my time is up. I have just a couple of very quick points, if I may.
Go ahead.
Harassment, okay? If I don't know what the issues are, of course, I'm going to have to subpoena everybody I possibly can because I don't know who I'm going to need to rebut whatever evidence it is that they choose to put on. And that also goes for documents. You know, why would I subpoena any given document that may not be relevant, but I don't know what it is that the employer is going to be disputing? I would like to just give a quick example of why this position statement is necessary.
If you can do it in a minute.
I can do it in less than a minute.
Okay.
Just this past week, my office handled in our case. Prior to the hearing, the employer simply disputed the unit, didn't agree, didn't really say why. A day before the hearing said, well, this is a multi-plant unit. We don't agree with your single plant. The union said, okay, fine. I'm sorry, they backed off of the multi-plant and said, if you'll include this particular classification. The union said, fine, that classification doesn't exist at the single plant, so include it. I don't care. We can bargain about it later. On Monday, when the hearing started, the employer renewed its multi-plant facility argument, tried to include the classification that didn't exist at the unit at the plant that it had already agreed to. Thereafter introduced multiple issues of supervisor and individuals who didn't belong in the unit. After 6 days of hearing, and you can imagine the record must look like this. 6 days of hearing, on the last day, it backed off on its multi-plant unit, and it's back to a single plant unit.
Okay.
That kind of wishy-washy cannot be allowed. Thank you.
Mike, go ahead.
Mr. Baskin.
Oh, wait, sorry.
Oh.
This is like when you see a few outfielders watch a pop fly drop right on the outfield. First of all, thanks for coming. Just two quick questions. Federal Rules of Civil Procedure Model and Civil Procedure Models in terms of civil litigation generally allow an amendment before some pleading that is going to bind a party goes into force. For example, you get a free amendment as of right with your complaint in many jurisdictions. What's your position on allowing the employer one free amendment or an amendment on one issue or two issues or three issues?
Well, before you answer, that was exactly what I was going to ask, but I was going to ask a little bit differently. Based on what you've said, should there be what period of time to change the statement of position, and should there be a standard, and what should it be?
Well, I would encourage the board to consider requiring the position statement come in maybe the day before the hearing, because I suppose if it's coming in the day of, we're still facing the idea if they haven't previously articulated what the issues are, we're still in that position when we show up with the statement the day of. I suppose, amendments, the hearing officer and the regional director, of course, have the discretion to define the scope of the hearing. And as the evidence comes in, it becomes apparent that there is an issue that wasn't raised in the position statement. It's the board's job to make sure that an election, the direction does conform to the law and that the unit is in fact appropriate. And so I think the amendments come that way. The employer's had a lot of time to review its position prior to getting to the hearing. They know what their workforce is. I think what I see the waiver going to is prohibiting an employer from playing these games, from changing its position from day to day just to confuse the issues, confuse the hearing, and add to the delay before an election can be held.
And one quick thing on the heels of Nancy's great point there. What if day 6 position statement instead of day 7, but day 10 hearing to allow, or day 11 or day 12 or whatever we end up deciding on? So the position statement actually rolls out in some intermediate area that allows the parties to talk about a stipulated election agreement. What's your thoughts on that?
At the risk of upsetting anybody here, the two regions I primarily practice in are 13 and 25, and we have a pretty hard and fast 10-day rule in both regions. I would not actually object to that because I think it would be more beneficial to have that position, have a short opportunity to prepare for it. As my colleague said, we don't need 4 days, we don't need 7 days. But the 10-day rule, I haven't had a problem with. And they are, when they say only for good cause or extensions granted, they mean it. I've seen people rejuggle their schedules in Herculean ways in order to accommodate these hearings, and I'm not opposed to a 10-day.
Thank you.
Just one question. Have you had any experience with having to obtain witnesses in response to a position that the employer has taken at a hearing?
That has occurred. It's usually in the context of the employer doesn't wish to state its position prior to getting to hearing. There's been at least once where I know I subpoenaed the entire bargaining unit, and of course the region raised a question, and I said, fine, I'm willing to stagger, how these people are going to appear, but I need to have them on deck so that if I need to rebut something, I can do it. That raises the cost for the union, too. I can't serve a subpoena without a check, right? Mm-hmm. And if I don't end up calling the witness, I don't go back to that witness and say, give me my $50 back, please. So these tactics unnecessarily raise the cost and lengthen the time.
All right. Thank you.